For your patience today. So I did read the 170.6 that I had not seen earlier. So I'm going to rule on that, and then I think you would benefit from an opportunity to be heard. So I'm going to give you the floor, and then I'm going to rule to the extent necessary. All right? But I do think I should start by ruling on the 170.6.
Thank you, Lily.
So this was filed, and have a seat, make yourself comfortable.
Thank you.
This was filed January 24th, 2013, so I think it was filed this morning. I did review it. It's a affidavit of prejudice, peremptory challenge to judicial officer pursuant to Code of Civil Procedure, Section 170.6. It's filed, although it's not signed, as it's required to be, under penalty of perjury. The name of the party is listed as Elisa Spitzberg as a cross-complainant. To my knowledge, Elisa Spitzberg is not a party to this action, and there has been no cross-complaint filed to my knowledge. Under 170.6 subsection A2, the statute clearly sets forth that the only person who may file an affidavit of prejudice are a party to or an attorney appearing in an action or proceeding. So based upon the fact that there's no Elisa Spitzberg listed as a party to this action, I'm denying the affidavit of prejudice.
Could I ask a point of clarification, Your Honor?
You know what, this is your time to talk as you wish, so go ahead.
Well, I have a question before I use my time, if that's all right.
I'll rule at the end, okay? I'm not going to answer questions back and forth, but I will absolutely address everything at the end. So go ahead. As I said, I think that you definitely want an opportunity to be heard, and I want to give that to you, so go ahead.
I appreciate it, Your Honor. And I am definitely not an attorney, and the court is actually questioning my competency, so I will defer to the court, but my understanding is that according to 170.1, Section 6III, that it states actually that the judge can recuse themselves with knowledge of a cross-complainant if the cross-complainant has not been properly filed. It's my understanding that the judge has the prerogative to make that decision on your own if you feel that there is enough evidence to indicate any sort of bias or inability to be impartial with this specific case, that you have the ability to make that decision most respectfully yourself, even if the cross-complainant wasn't properly filed. But my understanding is that it's coming in from Georgia, and that the court needs a wet signature, so that is awaiting an affidavit, and that you need to receive it within 10 to 15 days of the hearing, so I think that's why it was sent in today. Also, there's some confusion about Mr. Taham's jurisdiction with regards to this case and his non-appearance today, and some confusion with when the court made a decision about it going from a non-appearance to an appearance. And I would like clarification on when that decision was made, because the court was understanding that I was out of town. So it's of particular inconvenience for me to have to be here today, but I want to be very compliant. And I would like to ask the court and Mr. DeCarteret if you have both taken sworn oaths of office to protect and serve the Constitution for the United States of America, as well as the California State Constitution of 1849, before we proceed. If it pleases the court, I would like to respond to that.
Go ahead with the other issues you want to address, please.
But I would like to know if the district attorney has taken that oath.
Mr. DeCarteret off the record.
Unfortunately, he refused to speak to me, as your clerk can attest to, and I had to actually get the name of the DA from your clerk. Most respectfully, he is refusing to cooperate whatsoever in the interest of justice. So I would like the court on the record to ask him if he has taken a sworn oath so that I may accept it.
That request is denied. All right. What else would you like to say?
Okay, my other concern is that I would like to have a Mergia motion heard, because my case is being charged by the city attorney's office, and it's my understanding that it is a big no-no to have Mr. DeCarteret of the District Attorney's Office prosecuting these charges. It's my understanding that could be some ex parte communication, and since there are questions with regards to this case and my alleged violations of due process according to the 14th and 6th Amendments, I think it's very relevant if Mr. Carteret actually has the standing to prosecute these competency charges. That is one question.
Okay, go ahead.
My other question then is why the court and Mr. DeCarteret, as well as the State Bar Panel Defense Counsel, which I have begged, pleaded, and asked to get off my case literally and figuratively in the most respectful and potentially contemptuous ways that I could even muster. And Mr. Tahan, if it pleases the court, not only refuses, but stated in a backdated letter January 2nd that was postmarked January 11th, confusingly enough, stated, please stop exposing your case to others. He also stated, until you show me that you are competent, I will press the court to keep your criminal case suspended. With most respect, Your Honor, when we first met on December 20th, which to my understanding is the first you ever laid eyes on me, when you made an unsubstantiated competency ruling, and I most respectfully feel that I am more than competent, I'm very confused why neither you nor the attorney nor Mr. I'm sorry, I only just learned his name right now, DeCarteret, why none of you informed me of my right to a jury trial for competency. I would like very much my jury trial with regards to competency because I have incredible concerns about the competency, most respectfully, of this court, because the decision has yet to be corrected on the court order that shows that you approved me to be medicated and I'm a nonviolent misdemeanor. And federal case law would suggest that that is totally unlawful. When I asked Judge Barella to correct the minute order, which came most respectfully from your court, he refused. So I am finding myself at an impasse where my very liberty is being curtailed at a far greater cost than that which if I had been left in the criminal justice system. I very much appreciate your time and would like to remind you that according to USC Title 42 and USC Title 18, that if I accept your valid oaths of office, if you, including the prosecutor, has full knowledge that these charges are false, it is not only your obligation and your privilege, but your duty as an oath keeper to dismiss the charges in the furtherance of justice. So I want to be very clear on the record that there were no Axis 1 findings, according to Dr. Ochoa's report, which no one gave to me upon begging and pleading, but I finally did receive a copy of from Mr. Tahan, and I have concerns. I would like the court to revisit that paperwork. There is no diagnosis. There is no IQ finding, as is in the DSM, or the required competency evaluation for the court. And I also have an email from Dr. Southard, who is Ms. DiBiasio's supervisor and the head of the Department of Mental Health. He stated that this is a legal issue, not a clinical issue, most respectfully, Your Honor, and that it is fully up to your jurisdiction. You have the ability, it is my rudimentary understanding, to rectify this flagrant malfeasance of justice with your good sense, and I am begging and pleading the court to do so. I would like you to look into these issues, including prosecutorial misconduct in the light of the death of Aaron Swartz. I beg that the court not wait or continue another moment with full knowledge. And I would also most respectfully like to remind you that when we did first meet on the 20th, in the Marsden motion that apparently is sealed, but I have nothing to hide, you did say that if you had heard the motion prior to the doctor's findings, you would have considered it and granted it, but you actually stated on the record that because you heard my Morrison motion after the doctor appointment, that you would let the ruling stand. And most respectfully, in light of this exculpatory evidence that is material to my defense and my good name and my competency, while I'm currently running for mayor of this great city, I think it's very important that this court not take lightly unsubstantiated competency rulings and that we look at this very, very carefully. I'd also like to point out that Dr. Ochoa's report accuses me of being a narcissist and grandiosity, most respectfully, both of which are Axis 2 personality disorders. Most respectfully, I would like to submit to the court that if it is true that my only diagnosis is that I am annoying to the court, it is most certainly true that that is incurable, and I am likely to be annoying for the rest of my natural life. So I most respectfully submit that being annoying, while it may keep me from finding the happiness of a 42-year marriage like my parents have, and I might be single the rest of my life, that is also my right, and it is not a crime to be annoying. So I respectfully ask the judge to reconsider, nunc pro tunc, reevaluate, or whatever is in your great jurisdiction to do, but that you not let this malfeasance of justice continue any longer, and that you please correct the court's order and please clarify with Dr. Southard. He finds that it is very important that my competency be restored as quickly as possible, and I would like to state for the record that I refuse consent that my competency was ever questioned in the first place. I do not wish to have my competency restored, Your Honor. I wish the court to acknowledge that I was never not competent. And it is very clear that I am not only assisting meaningfully in my own defense, but actually with alacrity, helping in the nicest way possible your court staff to learn about things like media requests, or the right to use, or what is a motion picture camera, as well as what is jurisdiction in the nicest possible way, in light of the fact that I am grieving a miscarriage of my very first pregnancy that is documented to have happened in custody. I think with all of this full knowledge, it is disturbing and alarming and shocking that this perfect storm of errors should have occurred whatsoever in the great Republic of California, but I pray in the interest of justice that the court will do the right thing, whatever that may be. I'm at a loss to actually understand what my remedy and recourse is, because my understanding is that my right to due process has been so violated that this court doesn't even have jurisdiction. So I'm throwing myself at the mercy of the court. While I'm more than competent, I am confused. And also, I find it hard to believe that a narcissist who doesn't care about anyone would be so concerned and the only person in public view to ask this rude man if he was okay when he fell in full public view. And I didn't even know who he was, but I was so concerned, was he okay? And he won't even tell me his name. So thank you so much for your time and for letting me be heard, because I'm feeling not heard. So I really appreciate that more than anything else. Okay, anything else you want to say before we go into the court hearing? I asked about the jury trial, and I asked about the conflict with the district attorney and the city attorney charges. That's confusing. And I asked about the appearance, non-appearance. And I guess my last question is that my understanding is that anything that I say can and may be used against me in a court of law, including this one. And I would like it on the record that it is alarmingly of concern to me that I am here without proper legal counsel. Oh, and the last thing, Your Honor, is my understanding from Zeke Perlow of the ICDA is that only you can officially withdraw the attorney since he has refused to sign a substitution agreement. And I think that this is well beyond any situation or normal situation of competency versus ability to assist in counsel. I think it's odd that counsel is refusing to assist in the furtherance of justice. And I think that things like refusing to give one's name on the public record is just rude and unbecoming of a member of the state bar of the great state of California. So those are my 4 points. Thank you, Your Honor.
Thank you again, for your patience and for your comments. I made note of the many things that you brought to my attention, and I will take to heart all of them, especially your wish to the court to look into these issues, and I'm going to take them under submission, and I'm going to rule on the issues and urge you to discuss all the questions that you have with your attorney, and I will take them all under submission and continue the matter to Monday, the 28th of January, and order you back at 8:30. Thank you. Have a great weekend.
Wednesday, Your Honor?
Do you want Wednesday instead?
It would be better.
Wednesday the 30th works for you? Okay, at 8:30, so your order is back then, and we will see you then. Thank you.
And Your Honor,
We'll
could I
be in
get a
recess.
copy?
Thank you.
Could I get a copy of Ms. DiBiasio's report since the attorney won't
Sure.
give it to me? Yeah. Thank you so much, Your Honor. Thank you.
If it wasn't clear, Robert.
We'll be in recess. Oh, thank you.
Thank you.
Thank you. Thank you. I'm glad you remember your name. Thank you so much. Okay, thank you so much. Good job. Thank you. Be careful. And then I'll get this, I'll wait here for a copy of Ms. DiBiasio's report. She just said
I think the clerk's going to get it for you.
So, wait.
I'll bring it to you.
I'll bring it to you. We'll just wait
Okay, right, because the clerk